Good evening and welcome to the second in our autumn series of financial remedy webinars. I'm joined tonight by Andrew Pote, and we're going to be talking about overseas assets, something that we're all faced with in many of our cases. And so we'll try and give you our best tips for dealing with cases with international elements as smoothly as possible. Tonight we're going to be talking about spouses in Matrimonial Causes Act cases, but the principles apply equally to civil partnerships. So Andrew, would you like to get us started?
Well, good evening everyone, and welcome to our webinar on this topic of overseas and foreign assets. It's obviously born out of our practices now that we come across this aspect in financial remedies cases very much. And we live in a multicultural international world with a number of marriages between spouses from different countries, sometimes with neither from the United Kingdom, coming before the courts seems never to have been higher when it comes to assets overseas. And we're very much trying to approach this on a practical basis to give you the benefit of experience, as well as talking about some aspects in law with regards to certain issues.
Yes, I certainly feel that issues of foreign assets are rising increasingly in the cases that I'm dealing with. So let's have a talk then about the general principles, Andrew.
Well, the general principle, of course, is that under the Matrimonial Causes Act, and of course Civil Partnership Act as well, whatever I say goes for both, is that it's not confined to assets held within this jurisdiction. It applies to all assets of the couple, wherever they're situated. And where one party or both have an interest in a property which is located outside the jurisdiction, is still property or financial resource the court should have regard to under section 25(2)(a). And of course, we are dealing with a number of cases where one party will have a property or an asset in one country, possibly their home country, and another will have from their home country, which will be a different country, and they're asking an English court, because that's where they live now, or Welsh court, to decide about those assets, because that's where they've decided to get divorced. So those are the issues really which we're looking at, and how we deal with those effectively on a day-to-day basis in cases which don't necessarily have to be that involve a lot of money, big money cases as it were, but also run-of-the-mill cases really, which have assets outside the jurisdiction.
Yes, when you think about the range of property that we're talking about, land, bank accounts, as well as trusts, companies and pensions, or even baits and other chattels that are held abroad, it's quite easy to see how those issues arise in the range of cases, so the small money right up to the bigger money cases as well. So Andrew's going to talk us through some of the problems and issues we're going to be trying to tackle and provide our tips on tonight.
Yes, and of course in these cases there will also be arguments about pre-acquired assets, non-matrimonial property, inheritance and post-separation accruals. But we're not going to deal with those. We're just looking at these topics on the list. And the first one, which is obviously at the beginning of the process, is disclosure. And this is vitally important because the starting point is that a client must disclose all their overseas assets, a party to the proceedings. And it's essential, if you play a role in this, that you make sure that all their assets overseas are disclosed, as well as those obviously within the jurisdiction. And the problem is that if they're not disclosed and they come to light later on, it may be grounds for setting aside a final order. And certainly there have been cases where people have tried to set aside orders because they say there was a non-disclosure of foreign assets. And also it doesn't look good if the first time a party has to reveal that they have an overseas asset is when they're asking a question in the questionnaire from the other side, or in fact that the other side says that they've got an interest in a property which that spouse has, and in fact that spouse hasn't declared it in their Form E.
Just coming at matters from the other side, for a moment, thinking about dealing with deficiencies in disclosures. We'll be familiar with the questionnaire question asking for the signature on a PN1 to make the search at the land registry. And interesting to note that some of the other legal systems, depending on where an asset might be based, do provide methods of searching national property registers. So those sorts of inquiries into disclosure really come down to local knowledge, and that's a really key, I think, to what we're both going to be saying tonight in terms of dealing with foreign assets, is that making those initial inquiries as to the law and the procedure in the country that the asset is based is really key to having a successful outcome. So other than that, it can be quite difficult to try and identify property in another jurisdiction, especially if you don't know where it is. But assuming you do manage to find the property, then it may be that you need to think about protecting it by way of an injunction.
Yes, and an injunction under the Section 37 of the Matrimonial Causes Act, or under the Senior Courts Act 1981. The court can freeze foreign assets on the basis that a freezing injunction acts against a person rather than the property, and that was as far back as 1986 in the case of Hamley. And that's a power which is probably best used, because if one goes into the High Court power to grant freezing injunctions under the Civil Jurisdiction and Judgments Act 1982 in the Interim Relief Order 1997, you're into having things like the party applying for the injunction having to give an indemnity for damages, and of course identifying lots of individuals who may have to be served with the injunction. So the Section 37 procedure is simpler. Don't forget that to apply for Section 37 order, you have to have proceedings underway. But it's an interesting thing to realise that, in fact, from this case came the concept set out really also in the Financial Remedies Dictionary, some of you may have, where you will see that they then say that it leads on to the court having the power, by analogy, to make adjustment of property orders on foreign properties. So that's interesting to look at in terms of that. The bottom case there gives you, it's a civil case, but talks about the powers of those injunctions. And if you really have that sort of case, then it's important to know about that and what is required.
Yes, and just on another practical tip, see when applying for injunction, one of the steps before that might be to try and take some local advice on whether there's any way to place a restriction on the property whilst proceedings are ongoing in that country, which might mean that, much like placing a restriction at the land registry here, would mean that an injunction might not be necessary and some costs could be saved there. So we've got our property, we've got it protected. Let's look then at how we value it.
Well, valuations are obviously key, but some countries, obviously, you will know, have a very different land registration system to England and Wales. And that, for example, India can be a difficult country to access land documents and obtain independent valuations. No one document guarantees the ownership, and it's established by a number of documents, including registered sale deeds, record of rights, property tax receipt, and government survey reports. So it is very important to identify the property. And moving on, it's very important when you're instructing an expert to give a valuation that you state the exact address, and obviously this needs to be agreed with the other side, especially if the property is part of a building, for example, a flat, apartment, or a shop. There are a number of cases where there are arguments about what actually is the property. And fields and building plots can be especially difficult. And you need the person doing the report to comment also on if it's going to be developed, what planning consents it has, or what planning consents are required for development in that country, to make sure that the value that's being placed on it is correct and is of use to the court.
Yes, and some real difficulties can arise in cases in countries where property might not have a recognisable address, or there's no land registry. And in fact, I was involved in a case some years ago now, a case of actually very modest means, and it was involved two parties who owned property in Nigeria, or one of them did. And there was a dispute about which property it was that the party actually owned. And in fact, we weren't able to find a proportionate way of identifying which property was owned through any of the procedures in that country, one of which we had two properties in contention and photographs of them both. One was an undeveloped plot and the other had a house built on it. Obviously, there was a dispute about the valuation of the two properties, and ultimately the court ended up having to simply hear the evidence of the parties and make a finding of fact at the final hearing as to which property was owned and which property was up for division between the two parties. So it just goes to show there's not always an easy solution to these issues.
Yes, that's right. And also with regards to the expert's report, if possible, the report should be in English, state the value in the local currency. This can be confusing in some countries where sometimes they will use the old style of currency in terms of its name, and sometimes will use the new style. That is particularly true of the case I was aware of where there was property being valued in Iran, which caused a bit of difficulty. And also the sterling exchange rate that they used at the date of the report. So that, that obviously then can be looked at later on when you come to the date of the hearing to adjust the property value. And also, this is something that sometimes can be forgotten in instructing experts, particularly a single joint expert, to value a foreign asset, whether it's property, a company, or whatever, that they must understand the nature of their duties under Part 25, the Final Proceeding Rules, about experts and their duty to the court. And there are a number of cases where particularly this is an issue where one party is in the country where the property is and the other party isn't. And the temptation of the valuer to speak to that party or to be shown around by them or members of their family or whatever. And that needs to obviously be avoided wherever possible, so that the expert understands the nature of their role in providing a report to the court.
Yes, the party who's out of the country can often feel at quite a disadvantage in the appointment of the expert and the selection of the expert. And so having a transparent and clear process for identifying which expert's going to value the property can be really important in those instances. And of course, as Andrew says, the emphasis on the duties under Part 25 is absolutely vital. Let me move us on. Sorry. There we go.
Thank you. The number of cases which I've dealt with where, although an asset has been disclosed, or sometimes the reason why it wasn't disclosed initially was because they were saying, well, that really is an asset that I own with a load of other people in my family. It can never be realised. We can't sell it. It's worthless or whatever. And circumstances are as in terms of the law here, as Lord Justice Wilson said in the case that we quoted there, Bizzardi and Bizzardi in 2008 in the Court of Appeal, that unless in proceeding to unsee relief the court considers it to be its duty under section 25 to inquire into the matter itself, it is for the owner of the property to establish, if such be the case, unless it is self-evident, that its value cannot be realised. And this is the important part, which is often overlooked, which includes being borrowed against, Newton and Newton in 1971 family law reports, or if realised that its proceeds cannot be transferred to the place at which is suggested that they can be deployed. Now, this can be an argument for some people to say, well, although I could sell the asset, I couldn't get the money out of the country because of the currency rules prevent it. Well, that's for the party who says that to prove it. And unless they can prove it, then the asset will be counted for its value, or the share of the value that the other spouse has in it, in terms of the assets to be distributed and decided upon.
Yeah, it's an extremely useful case practically. If you're on the right side of it, that's the side of the party who says that the asset has its full value. If you're the party trying to establish that the value is non-realisable, then you really have to start thinking about what evidence you need to bring that before the court and establish it, whether that's expert evidence, valuation evidence, or other evidence relating to the law of the country in terms of transferring out assets. Also in that case, interestingly, and as a bit of a highlight of the potential traps we can fall into in cases involving foreign assets, the wife had transferred to the children the property, but had retained a life interest and a power of attorney. And the law in that country meant that she remained the absolute owner of the property for the period of her lifetime, rather than simply having a life interest as we understand it in this country. And so it highlights really the importance of drilling down, of getting that local evidence, of understanding what the terms that we understand in a particular way in this country mean in another country, and not being swayed by the use of recognisable terms to applying our law to the problem. So let's have a talk about true ownership. Obviously, issues involving interveners arise frequently in our cases.
Yes. Well, this is the case that we Gaddafi, where the Court of Appeal in 2015 supported His Honour Judge O'Dwyer's determination that a property held by the husband's mother in India, but founded on his income, was a financial resource of his. However, the Court of Appeal did allow the appeal on the second ground concerning the value of the property of £400,000 net. There was no evidence to support this, and the case was remitted back to the judge for directions as to valuation evidence and a rehearing on the question of the valuation upon which the quantification of the terms of new order would depend. Now, obviously, if property is in dispute, as this property was in this case, much better, even if it's in dispute, to get a valuation of it, so that if there is a finding that it is property of one of the spouses in the case, then obviously it saves that issue of then having to adjourn the matter for evaluation. But obviously there can be problems where a non-party is saying that they are the legal and beneficial owner, and of course they won't cooperate and won't give access to a valuer to gather their evidence for their report. So that's something to be identified in terms of getting agreement between the other person, if possible, so that evaluation can take place, so that you don't have that hurdle to overcome. Otherwise, obviously, where you've got third parties claiming to be the owners or part owners, then of course that may have to be dealt with in the relevant foreign jurisdiction first. That will obviously be very fact specific, depending on how the claim is made and whether, as far as we understand it, is the claim to be the legal owner and the beneficial owner, or just the legal owner, or the beneficial owner, or having an interest in it. And I just comment there about the articles, obviously, which were the recast Brussels I regulations, which are being applied up until, of course, our proper withdrawal from the European Union. And of course, any proceedings, I think there probably are still proceedings going on, which were issued before the 31st of December 2020. But after that, the article has no application to proceedings issued since that date. And so it's interesting to look at the jurisdiction that the court has been operating on in terms of even dealing within that and moving forward in terms of how we will deal with it now that we have completely left the European Union. Now, this is a little bit of an unusual case, and these two cases a bit of a diversion from normal financial remedies, but in Webb and Webb, this concerned an application concerned with the father applying for declaration in the English court that a flat held in his son's name was held on trust for the father who had provided the purchase funds. So this was a person here asking the English court to determine his interest in a property in France. In fact, it was done in Antibes. And the situation was that his son was arguing that the court in England had no jurisdiction. And went to the Court of Appeal, who asked what was then the Court of Justice of the European Communities to decide whether or not this was an issue that, although the property was in France, that the English court could decide. And the answer came back that the application was an application to rights in personam, so they would belong to the person, not rights in rem, and could be dealt with in the English court. So what the situation was obviously the father had no record of it being in France as being the owner, but his claim was based on the fact that he provided the purchase funds and it was being held on trust for him. And therefore it was allowed to be dealt with in the English court. And the case below it, although it concerned spouses, was actually proceedings brought under Talata because Trust of Land Appointment of Trustee Act, because the couple who were both from Poland had the property in London owned by the applicant wife and her husband, and they'd gone back to Poland in 1991. And the husband in that case was saying that, oh, based on the Webb and Webb, in fact, the matter shouldn't be dealt with here because it should be dealt with in Poland because they have jurisdiction to deal with it because we're concerned with rights in personam. But the Court of Appeal held that no, this court had jurisdiction because the case concerned rights in rem, because it was quite clear that both parties owned the property. They weren't claiming that they had a beneficial interest in it. They were the legal and beneficial owners. And she was applying for an order for sale of the property. And the property was in this jurisdiction. So that this was the right court to deal with it, notwithstanding that the couple had moved back to Poland many years before it came before the court.
Thank you. So quite a lot to think about there in terms of foreign properties. And of course, those issues are arising just all the time with people having bought holiday homes. Some of the issues that we've touched on seem to arise in lots of those cases where people have bought holiday homes or plots of land intending to develop them and often say they're worth very much less than they paid for them and that they can't get rid of them at all. And those sorts of issues are arising in many of my cases. So hopefully some of those tips and bits of advice will you'll find very helpful in respect of dealing with those sorts of cases. Let's move on though to talk about trusts, which probably arise in a few less cases, but no less complicated, of course.
Yes, well, trusts. Of course, not all jurisdictions have the same concept of trusts as we do in England. But where you have a case involving assets which are held in trusts, then obviously it will depend on the type of trust it is, what the property consists of, and whether it is something which has been set up as a tax avoidance scheme, so that the person may not even be domiciled in this country for tax purposes, or the income derived from the trust is something that they are keeping offshore for tax purposes, or the income is coming back into the United Kingdom, or where if they're domiciled abroad, then wherever they're paying tax on it. Now, of course, the problem with trusts is that, as I say, you really need the specialist expert tax advice if you're dealing with a big trust, and the case would be proportionate in terms of the amount of the assets to warrant that special expert advice. Of course, the problem with trusts is that the party who is said to be a beneficiary under the trust is, of course, not the legal owner. We all know that the legal owners are, of course, the trustees. And there have been a number of cases where there have been problems because the trustees will not engage in the process. And so therefore, the courts have very much had to have a degree of realism in considering whether they're going to deal with an issue of trusts, and also consideration of whether the tax liability is likely to be incurred. And two cases which we put there, which you may well be familiar with from your own reading, is that in BJ and MJ, an HSBC Trustees Channel Islands Limited, Mr. Justice Mostyn refused to adopt the husband's approach of calculating his assets on the basis of a value after the deduction of tax due on the reparation of the offshore assets, stating that this is completely unreal. The whole point of the structure is to avoid paying tax, and H has never remitted any offshore income. And a similar approach was taken by Mr. Justice Bodie in the second case in K&L in 2010. He only deducted tax on money from the offshore funds which he determined the wife would be likely to remit back in due course. Now, this was a case which involved, in fact, the wife inheriting a number of shares. And at the time of the marriage, they were worth just under £300,000. So they were inheritance which had come to her pre-marriage. But at the time of the final hearing, they were valued at £57.4 million. And the award to the husband by the court was £5 million. And there was an argument over whether capital gains tax should be considered and taken into account on the monies that the wife would have to pay to the husband. And in that case, the court decided that they would take into account capital gains tax on an arbitrary figure of 10 million. And Justice Bodie said that was the best way to produce a fair and realistic determination of the assets. So that was the issue there. But of course, other problems have arisen in cases where the court has tried to vary the terms of a trust and try to get the trustees to comply with it. But the trustees, having failed to submit themselves to the jurisdiction of the court have really declined to do so. And there have been cases which you can look at about cases which have gone, particularly cases involving Jersey, where cases have had to have been brought not only in the English court, but also in the Royal Courts of Jersey and also in the Court of Appeal there, about how trusts should be worked. And that's one of the things we'll look at when we come on to looking at enforceability.
Yes, and it's another point in my sort of theme for this evening, which is really to say, when you're dealing with foreign trusts, a trust where the assets are abroad and the trustees are abroad, governed by foreign law, and it is to get that advice early in terms of understanding what can be achieved in terms of any trust assets that you are saying, if you're the other spouse, effectively called to be the other side's assets in one way or another. And some of the routes, of course, we take, Andrew said, is applying for a variation of the settlement. You need to know how the foreign court is going to deal with that and how it's going to respond to an order from this court, and that will vary, of course, according to jurisdiction. One other point to make, because it's a point that arises in relation to trust, sometimes in relation to companies, of course, is where one party alleges that a trust governed by foreign law is a sham. And that, of course, takes us back to Sharman and Sharman back in 2007. Where that's an issue, and of course it's not an easy issue to prove, because one has to show from the outset that both the settler and the trustees were viewing the trust in that way. But where that is an issue, it's an issue that may well need to be determined by the court in the relevant foreign jurisdiction. And that again will turn on those issues that we're going to come on to in terms of enforcement of what the law is there and how it might be applied against an English judgment. So we'll come on to those issues of enforcement, because this is one area where we'll be saying that enforcement has to be at the forefront of thinking from the outset of the case, rather than once the judgment's been obtained. Let's have a look at the issue of pensions, because, oh, if I can turn the page, apologies, because of course pensions likely to be the second biggest asset, if not the biggest asset, in many of our cases.
Yes, so obviously an overseas pension is clearly an asset to be taken into account by the court, but how are they going to take it into account? Now, it was thought before 2016 that in one of the first cases involving Goyle, which is on the slide, that, because there were a number of cases, you can see there's number 3 that I'm referring to, the court could make a pension sharing order in respect of a foreign pension, but that's not the case. And it's accepted that pension sharing orders are unable to be made in relation to a foreign pension. Again, you have the situation, of course, where the important people in the pension administration, the trustees of it, or whatever they're called in the jurisdiction where the pension is kept, obviously are involved. And one of the, after a series of the cases and a Court of Appeal decision, what Mr. Justice Mostyn was left deciding in the number 3 case there in 2017 were 2 things. Firstly, could a pension sharing order be made in relation to a foreign pension? And he said no. And the second thing was, well, how are you going to get some kind of fairness into taking it into account? Obviously, in a case where there may not be a lot of other assets in the case. Now, this was a case where there were a lot of assets to begin with, but there were issues over how the husband had been dealing and disposing of them. And it came to also a case which spent a lot of money in costs. If you want to look at the authority and see how much was being spent, it's quite eye-watering. And what he decided was that what he would do is that he would make a periodical payments order. And the Indian pension, which was held by HDFC Life, he decided should be made the subject of that order of periodical payments by 2/3 of the quarterly income from the annuity policy as it arose and was paid to the husband, and the husband had to pay it directly to the wife's bank account. He also put in a bolstering injunction against the husband, ordering him to do that. He did hope, as he says in his judgment, that he hoped that those who administered the HDFC Life Fund pension would make those payments direct to the wife when they saw the order, including the bolstering injunction, but he accepted that he had no power to make them do so. So that's an important indication, and that case is really useful to look at in terms of what was happening there, and a way of making an order which was what he considered to be a fair way of dealing with the discrepancies and the assets in the case. Now, obviously, there can be a case where if there are sufficient assets, then you needn't worry about the pension because they can be offset by other funds, other property or cash capital that's available. But where there isn't, another way of maybe dealing with it is, and I've seen this in a case where a lump sum payment, once the pension is in payment or capable of drawdown, can be made in the right circumstances. Obviously, one has to bear in mind the ability of the court to make a lump sum order and make a lump sum order payable by instalments. But that is something also that can be considered. But if that is to be done and it's deferred to a time when the payment of the pension happens or drawdown is possible, it is very important to understand how the pension works and what the tax implications are when an overseas pension becomes payable, not just in that jurisdiction, but also for money coming out and back into this jurisdiction, if that is what's going to happen. Because many overseas pension schemes have a completely different taxation system to us. And there are ways, as Sean will say, about other countries, how they deal with the pensions, particularly in America, some in America and in Germany.
Yes, I mean, it's such an important issue, and of course we've all had our attention drawn to sometimes by the Pensions Advisory Group to the complexities of pensions just in this jurisdiction and our lack of understanding, as it were, to the issues that the experts can advise on in those cases. And even in cases where you're going to be looking at offsetting because you don't want to grapple with the issues of trying to implement any sort of pension order or other order against a pension abroad, you're faced then with the fact that pensions, even if the terminology is similar in terms of the pension fund, are not necessarily valued in the same way. And one needs then some expert advice as to how to obtain a valuation or calculate a valuation that can be used within this jurisdiction to assist the court with offsetting. So that's a really important point to bear in mind. And given the difficulties, this is just a sort of a side point, the difficulties in respect to pensions and how important they may be in certain cases, it may be that affects the parties' choice of where to have their divorce proceedings, so their forum choice as well. If parties are in agreement and they're collaborating and trying to reach a settlement, matters are often much easier, of course, in every issue, but in terms of foreign pensions can be made easier. So one has some possibilities that might arise depending, of course, on the expert evidence that you get at the time. So it may be possible to transfer for example, a foreign pension into a pension in this country, and then apply a pension sharing order to that. And there may be solutions available in other countries, such as the US, for example, where one can have an agreement with undertakings, and this is mentioned in Goyal, where you can invoke the jurisdiction that's the equivalent to our Part 3 jurisdiction and implement the orders there. But one also has to be aware of the local law, even if you're not intending to actually divide the pension or use any of the solutions that we've talked through, but you're really looking at offsetting. Because in certain jurisdictions, in Germany is a good example of this, pensions there are divided on divorce administratively. So wherever the divorce takes place in this country, in the cases we're talking about, the pension is divided according to a specific calculation which shares it between the two parties. And so, of course, that sort of knowledge is absolutely vital to inform your negotiations or to inform the court, so that it understands where the parties' assets are going to lie at the conclusion of the divorce proceedings. And so those are just a few aspects of the pensions which really, I think, draw attention again to the advice and local expertise that's going to be necessary. I think with what Andrew said as well, you may need at least two forms of advice in respect to pensions, looking at expert advice on the law and enforceability of any pension orders abroad, as well as specialist pension advice in respect of how the pensions actually work, what benefits mean, and also, sorry, it's three, isn't it? Tax advice along the lines that we've discussed already. And that's absolutely vital to understand what the assets are at the end of the day. So it's really important to understand the complexities, I think, of the pension issue and seek that advice, but also to remember those basics that we keep in mind for pensions in this country. So consider whether an undertaking is needed, that any pension freedoms which may or may not exist are not going to be exercised during the course of the divorce, or the pension's going to be transferred out of the jurisdiction. Maybe that's a possible way that a spouse might think of avoiding enforcement or orders against their pension. So I think a lot to talk about or understand in respect of pensions, and those issues lead in nicely, I think, to our discussion on enforcement.
Yes, of course, we end with enforcement in a sense, but of course it's where one really needs to begin, because the court is unlikely to make any order in respect of foreign assets that is not capable of being enforced. And that's the issue that is very important, and obviously is going to be one of those things which obviously is going to be proportionate to the time and money spent on the case, as whether at the end of the day, discussion on the assets that are overseas can really be worthwhile or not. And it's very important that the type of case will affect that, because obviously it's much easier if the person is a UK who has got to do something with the property, transfer it or whatever, or sell it, is a person who resides in this country, because of course they're much easier to be enforced against by the powers of the court and by proceedings for the enforcement of the order. But if of course they maybe return to their home country, or they've decided to go to a different country, as has happened recently in some cases, to avoid enforcement, then obviously that's important as well. So the likelihood of where somebody is going to be and the undertakings that you require from them, or ask the court to require of them, and the orders that the court makes of course, is important as well. And one of the things that is important is that make clear in the order by way of recital. This is if you're doing a consent order, obviously. You will have obviously put in the statements of the financial information anyway. With the consent order, and overseas assets should clearly be there as well and show how they've been taken into account, if not specifically mentioned in the main provisions of the order. But the problem with this is that if you don't do that, for example, and the asset abroad has not been properly dealt with, or it's been shown how it's being taken into account, it can lead to subsequent litigation by one of the parties in that country, when the other party thought they just got a clean break order in the English courts, and that property was theirs to do with what they wanted. So I came across a case, which it wasn't my case, but I heard about it, where the husband and wife both came from an Eastern European country, but they had lived in this country for many years, and they had property and assets in this country. The husband had a property in their home country, which was in his sole name. And it had been disclosed in the proceedings. And what happened was that there was also a value of that property as well. And when the court was deciding upon it, the court said that it had taken into account the fact that the husband had the asset in his home country and its value, and that therefore in those circumstances it was being taken into account in the order that was being made. Now, we would look at that with our eyes, would say, well, obviously if you looked at the situation, the award to the wife would reflect, for example, that the court had taken that into account, and that property in their home country in the husband's sole name went down on his side of the assets schedule being divided, and therefore that was it. Of course, what it didn't prevent was an application being made in the home country by the wife to say that she had an interest in that property. And the courts then in their home country had to decide what that meant. So it wasn't so much as like the equivalent of a part 3, where the wife, as I understand it, from the limited knowledge I have of it, was saying that she had been sufficiently awarded assets, but this was an asset which of itself had not been specifically dealt with. So obviously, even if you're having a contested hearing, it's important to then have at the final drafting of the order specific mentioned as to how that asset has been dealt with, so that it has been clearly taken, if it has been, in a similar type of case, completely taken into account, and as far as the court's determination is that the other party should have no interest in that property and no claim against it. Now, of course, with foreign jurisdictions, you can't be sure that that would prevent any application anyway. And of course, there is a recital in the orders now where we put in phrases like, the parties agree that neither of them has any legal or equitable interest in the property or assets currently in the sole name or possession of the other, owned by the other, and neither of them has any liability to the debts of the other except as provided for in this order. And of course, one has to consider what is the effect of that order when it comes to situation when the parties in their own country seek to legislate again in terms of assets not dealt with. So that's obviously something to bear in mind and to bear in mind at the outset of the case in terms of advising your clients as to what's the likely outcome in terms of the court making orders in respect of assets that may be very difficult or impossible to enforce, and also by assets being taken into account in this country, but the court making no decision in terms of the ownership of that asset clearly, because we're all used to orders in our everyday where if somebody is retaining a property or an asset, it often doesn't get, if it's in this country, it doesn't often get mentioned in terms of the order itself, because it's dealt with by the recital that they have no further interest in any of the property still owned by the other spouse. But in this situation of dealing with foreign assets, that may not be sufficient. Or it might be easier at the outset to say, well, here is a property which we know exists in another jurisdiction, and say to the client, actually, although it's not the most important asset, there are more valuable assets here, it still is a significant asset and one which should be taken into account. And it will be important that the court here knows what the jurisdiction of the other court is going to be, its approach is going to be to that asset, that standalone asset. And that although they are divorcing in this country, to actually have them, if they agree, to legislate in that country in advance, so that that determination of the percentage that either party has in that property is decided and then can be taken into account by the court here. So turning it on its head and saying if there is something specific, then that should be dealt with before the proceedings carry on here, so that they can then be factored in to the final award and the final order that is made. And it takes then the angst out of worrying about whether somebody is at a later date going to come back and attack an asset that the other side thought had already been dealt with under the order.
It's a really interesting point, because the preference often is to just make your claim against the assets in this country to avoid the difficulties of enforcement. And so it's just a really interesting insight into the potential pitfalls of taking that approach. In respect of the issues that we touched on earlier and the enforcement against trust assets, the issues vary, of course, from jurisdiction to jurisdiction. And as Andrew said, there's some case law, quite a bit of case law in respect of Jersey trusts. But really what one has to bear in mind when looking at enforcement against trust assets is that you absolutely need to know what the reaction is going to be of the local court to any orders made under the Matrimonial Causes Act, vary the settlement or otherwise against the trustees, and whether those orders are capable of enforcement in the other jurisdiction. Of course, Jersey says now that such orders are not enforceable there. And if they're not, are there other means of giving effect to the order that the court is wanting to make, as has happened in Merbarak, one of the important Jersey cases in 2008, where it was possible to find another slightly unusual route to achieving what the court in England was trying to achieve. Or whether there's another route through the interest of justice and comity that the courts will attempt to put the orders in place. And similar considerations can apply at an early stage as well, as to whether the trustees are going to provide the document and the disclosure to the parties that they need and that the courts needs. And at all stages, really, a really key part of it will be to try and get the trustees to submit to the English jurisdiction, which of course often they will not want to do. And that certainly can make a difference in terms of the foreign court's view on enforcement, as to whether they will look at the case and think that the court in this country has taken into account the trustees' views and that the trustee has agreed to abide by the judgment of the court. But more generally, as Andrew makes the point, and it's absolutely vital to know going into the case, really from the outset, even if it's not flagged by the court, is if I get the orders that I'm hoping to get, are they going to be enforceable? Am I going to be chasing around trying to get this award for years to come and depleting my funds even further? That there's just no way around getting that information in at the early stage, and then you can make some serious decisions about how best to target your approach at the assets in whichever jurisdiction they fall. So that just in terms of other potential pitfalls and enforcement, and Andrew's touched on this in respect of pensions, but there are in some countries, or maybe particular tax implications in respect of any of the assets that we've discussed, or there may be restrictions in bringing assets into this country from the foreign jurisdiction, and that needs to be considered at an early stage and not come as a bit of a shock once you've got the judgment that you were asking for and you go to try and obtain a local order or otherwise exercise it. So I think, Andrew, our theme really has been there's no substitute for proper local knowledge and expert evidence in these cases.
Yes, that's right. And it's important when embarking on a case to identify, obviously, how the foreign asset is, or the assets are best dealt with, whether here or in the country where they are, and the realistic prospects of enforcing orders. It's very difficult when somebody leaves the jurisdiction. It's very difficult when they've got assets outside of the jurisdiction, as some of the recent cases involving very wealthy so-called Russian oligarchs have shown, where it's led to a lot of enforcement applications, a lot of applications to seize property and whatever. And then it's one thing to get the orders, it's another thing to get them enforced. So one has to be realistic, and one has to take into account creating the arguments to show that there are sufficient assets to have, it may seem a very one-sided order granting to one party, but to compensate, as it were, for the fact that sharing up other assets which are in could be the control of the other party are going to be unenforceable.
Thank you so much, Andrew, and thank you everyone for joining us this evening. Our talk will be on our YouTube channel along with the handout, which I think will also be sent to you and will also be on the website if you need it. Do join us next time. We'll be back here, or I will be back here with Catherine Archer and Charmaine Clubb, who will be talking about the treatment of pets in financial remedy cases. That's on the 30th of November, same time, 5 to 6 p.m. So hopefully we'll see you then. Thank you very much.
Thank you. Goodbye.